Judge Cannon in Florida, RIPS Jack Smith, says, Jack, you should have brought this up many times before. You didn't, and because you didn't, I could have just dismissed your request right now and denied your motion, but I'm not going to do that because I am, in fact, a very reasonable judge. Now, the left likes to go hysterical over Judge Cannon because she's a reasonable person. They expect all of them to be like Areola Engeron, who just banishes Trump into the seventh circle. But Cannon's not going to do that, and we're having a debate now. This is the classified documents case in Florida about evidence. And as the public, as the American people, we want to see what the heck's going on in this case because they say Trump was in possession of all these heinous documents and so on and so forth. And there was this really dramatic investigation where the FBI had to go raid Melania's underwear. And they were telling us on late night TV and everything that Trump had nuclear codes that he was selling to Iran and all that garbage. You remember that? All fake news. So Cannon is now having to weigh a couple of questions in this case. We have discovery that is being disclosed from the government to the defense. And the defense is saying, we'd like to, kind of talk about some of these names, some of these people who are involved. We want to show you what they're talking about and who is connecting the dots. And we don't know why they might want to show us that, but we can suspect that it's probably because those names would be readily identifiable and we might be able to concoct, one of those yarn connection dots. Oh, we see the big collusion conspiracy now coming to play, being orchestrated by the Biden administration. So we're asking ourselves, right, what can we see? What can we not see? Judge Cannon came out with an order on this and she rips Jack Smith. It's going to take a little while to warm up this one. She gives us some background that we'll dive into, but then she goes into Jack, laces into him pretty hard. So stick with it and it will get juicy. Now on this date, April 9th, filed in the West Palm Beach Division, Southern District of Florida, cases United States of America versus Trump and the other co-defendants. This is Judge Eileen Cannon writing. All right, everybody, here's why we're here. We're here on two motions. One, Jack Smith is asking the court to reconsider. Okay, so Cannon came out with an order saying that a lot of this stuff's going to be public. We read a lot of these filings here, and if you want to get caught up on those, they're all on our channel. Jack says, please reconsider because if you do publicize this stuff, it's going to be the end of America. We know his standard line. And also, this is Trump's motion for leave to actually disclose the discovery, right? Trump wants to publicize this, and so every time that you hear someone on the left say, Trump doesn't want the public to see what's happening here, you just refer him to this video, okay, today's show. Just say, hey, dum-dum, look at this one. Trump literally files motions to disclose the discovery. Like, do you see that? Can you read that? Because that's what he's asking for, to share this with us. Same thing with Merchan's case. He wants to also have the records publicized, the judge's emails and so on, but they all deny that because they don't want us to see it. So Jack says, don't disclose it. Now, Cannon says, okay, both motions concern sealing requests that are associated with Trump's motion to compel discovery. And we've talked about many of those motions as well. And we're spending some time on this. It'll helps make sense of what we're actually talking about here. But remember, Trump also in this case said, Your Honor, there's a bunch of other material that we need from other entities like the NSA, Secret Service, Homeland Security. We got like a little sliver of the FBI. We need everybody else. We need DOJ, all these divisions. Like they wanted everything from all of the government entities because they're all related to classified documents, right? They're all involved in that process. And Jack Smith was like, no, we're just going to give you like what I worked on that one Saturday with Jay Bratt, right? So the disclosure from the government, Jack Smith is arguing, is just, a fraction of what Trump is asking for. So they said, okay, Judge, why don't you compel Jack to go get it? Like literally go to the CIA. The CIA was on the list, right? Oh, it's classified. CIA says it's all top secret or whatever. So if they're involved in this, if they're in the conversation about what is not classified, then we need to be apprised of those communications. So the parties filed their motion. Judge Cannon heard oral arguments. That was over a month ago on March 1st. And here's what the judge says. So Cannon writes, upon hearing this motion, Jack Smith's motion for reconsideration to redact and to seal some of this information is granted in part. So we'll see what's granted and what's not. Now, Trump's motion for leave to disclose discovery is also granted in part. Okay, so it's kind of like both sides get a little bit here. So the judge is going to catch us up. And I think this will give us a nice background on where we're at with all of the discovery in this case. And this is a very, discovery heavy case because we're talking about boxes of documents. So here is what Judge Cannon says. She says, all right, it's a little bit lengthy, so let's go to it. She says, here's the motion to compel discovery, right? We're going to call that the MTC, not to be confused with the motion to continue. It's a motion to compel. Now she says, all right, here's the deal. On January 16th, earlier this year, Trump filed multiple motions to compel. We read a lot of these. We're like, yes, let's go, Trump. Go get those documents, baby. Oh yeah. Now in the motion to compel, Trump sought an order defining the scope of the prosecution team because Jack Smith said it was like just him and his bro. We're like, oh no. You got like the whole stinking government involved in this. Okay. So we want all of it. So they also wanted to compel Jack Smith to produce various categories of evidence. That's Brady material, Giglio material, material, stuff that might exonerate Trump. And Trump also attached numerous exhibits in support of their motion to compel, some of which are documents that were produced by Jack Smith in discovery, right? So Jack Smith gave them stuff and they say, oh, look at this. This means we need more, like supplemental materials. And Jack is giving us a hint that there's something else there, right? It's like, oh, I know it's referring to something. So what is that? We need that. And others consist of materials that the Trump team got pursuant from FOIA requests, right? So Jack like inadvertently alerted them to it. And then Trump went around Jack and got it through FOIA. So then he knows, he's like, oh, there's a bunch more here. So consistent with the protective order, Trump then filed a motion to compel to make Jack Smith get all of their stuff. He filed it on the public docket and in partially redacted form, right? So he's showing us kind of what's coming. Now, they also filed, not only on the public docket, they filed a motion for leave to file their motion to compel in unredacted form with limited exceptions, saying, hey, these are presumptively public records, right? We're all going, yes, let's go. Like, we want to see this. What is being redacted here, right? They're fighting hard over this. Trump's saying, can we publicize this, please? Now here, defendant's motion to compel, this is from Trump, as well as the associated reply and response are accompanied by extensive classified supplements, right? We can't see any of that, much to our chagrin. Now, neither defendants nor the press coalition seek to unseal the classified supplements, right? So stuff that is already marked classified, they're not saying, let us see that. This is just like regular investigatory stuff. You know, they're not saying there's 34 illegal classified documents, they say, or whatever the number was. Now, the operative blanket protective order extends to all discovery and all of the approximately, the judge says, 1.3 million pages of unclassified discovery in this case have been designated by Jack Smith as subject to the protective order. All right. So we don't get to see anything. Trump can't share anything. So the classified stuff, obviously we're not getting. Okay. We say, all right, that's just, I guess, the cost of the national security state, which I think is ridiculous and way overbroad, obviously. Now, all of the approximately 1.3 million unclassified. So you say, okay, fine. If it's classified, we don't need to see it. What about the unclassified stuff? Can you please upload that to Dropbox, please, so we can download that on a Google Drive? Thanks. No. Now that's all protected by the protective order. How come? And even Trump's motions need to be redacted. Now the judge continues and says Jack Smith filed a brief in response, a generalized response to Trump's motion for leave for permission to file this stuff. And he called it a seal request. And in that seal request, Jack Smith opposed unsealing the motion to compel, right? Trump is saying, I need this from the NSA. I need this from the Secret Service. I need this from CIA, whatever. And he says, no, we can't unseal any of that. Here's a couple things we need to protect. We got to protect the identity of any potential government witness. So I don't know how broad that is. We also have to limit anything that reveals personal identifying information for any potential government witness. And so you might think of things like addresses, cell phone numbers, emails, which is usually, okay, fine. And three, also want anything that constitutes Jenks Act material for potential government witnesses. So these are notes, memos, any materials that they rely on in their testimony. Now, the seal request from Jack Smith, Judge Cannon is writing this. She's saying, okay, hey, dumb Jack, when you submitted this seal, you did not propose a legal framework to govern these requests. You just said, this is what we want to do. And you did not provide any factual support for that relief. You just said, this is what we need to do. And so Trump took no position on any particular request, but he argued that Jack Smith's generalized and vague claims failed to provide any sufficient factual or legal basis for the relief that was requested. And we read that here. We're going, what is he talking about? So on January 22nd, the Press Coalition, they also filed a motion to intervene and to unseal defendants' motion to compel discovery. The Press Coalition argued, citing authorities, that Trump's motion to compel, so this is the press, are presumptively public records subject to the First Amendment's qualified right of access, right? So they're saying Trump filed a motion to compel and we should see it. We don't need a bunch of redactions on there, like by default. Now, both sides responded to the Press Coalition motion. Trump largely took issue with their representation about Trump's responsiveness for conferral. The press was like, well, we tried to confer with Trump and they delayed. And they're like, we didn't delay for crap. You guys delayed. That's it. But they didn't fight about anything that was ultimately relevant. Now, at some point, we see that Jack Smith, later on February 2nd, Jack Smith moved to file sealed and redacted documents. And that motion largely incorporated some other motions as well. So Jack Smith responded and he argued that the Press Coalition failed to establish the elements of intervention. Okay, so Jack is not responding ultimately to the issue, right? Like, this is Jack Smith. This is a cop-out, right? Jack says, well, we're not going to respond to the press's First Amendment issues about why there's a presumption of access to Trump's filings. They just say they don't have a right to intervene under the federal rules of procedure. So sorry, it's just a technicality. It's like you don't have standing. Remember that? Rewind the clock back to our standing standing trauma days when every court was like, standing, you don't have any standing. And we covered that in 2020. But same type of thing is happening here, right? The special counsel's office is just saying they don't have standing to intervene, and they didn't respond. The court notes this. The special counsel's response did not object to the press coalition's invocation of First Amendment principles. Didn't say there was anything wrong with that. Just say they don't have standing, essentially. Did not meaningfully engage with any of the legal standards and did not offer any additional factual support. Okay, so now, Jack, you've had 2 bites at the apple on this thing, man, and you have failed both times. And then the judge came out and said, okay, like if you don't object to the press and your prior motion is just vague and, largely meaningless about danger to, the case or whatever, there's nothing there. So the court says, well, against that backdrop of that preceding history in the record, then the court came out, issued 2 orders authorizing the sealing of personal identifying information, but otherwise requiring that Trump's motion to compel and the attached exhibits be filed in unredacted form. And we were very excited about that. Oh, perfect. And again, I don't mind this personal identifying information stuff. There's this law of big numbers. If there's a bunch of people that get access to someone's email. So they say, judge says, guided by the strong presumption of public access to criminal proceedings. This is Judge Cannon, which is true, unless you're Jack Smith, who doesn't care about that. The court applied the unobjected to First Amendment standard, noting that neither party argues that the First Amendment does not apply to this, right? So Jack is just kind of sitting on his hands. So under this standard, the First Amendment, along with the well-established rules governing public access in the district, this court determined that Jack Smith has not set forth a sufficient factual basis, or legal basis warranting deviation from the strong presumption of public access to the records. Thank you. Right now, she's going to reverse a lot of this, so we'll see. But the order also set deadlines for the sealed submissions of the other parties to review prior to public docketing, right? So then Jack turned around and asked for reconsideration. So, catching up, Jack Smith had an opportunity to say, I object. He didn't do it. Neither time. Judge said, okay, well, First Amendment then seems like it outweighs the non-objection, and so we'll go ahead and unseal this. Jack was unhappy about that, so he turned around and said, whoa, you have to reconsider this. So on February 8th, just not long ago, Jack Smith filed an instant motion that we're talking about here, a motion for reconsideration. Judge, you made a mistake. Please do it over. Jack Smith argues that 1, Judge Cannon clearly erred in applying the First Amendment standard to the seal requests, which are instead governed by Rule 16 and a different good cause standard. So I guess Rule 16 overrides the First Amendment. And reconsideration is warranted to prevent a, quote, manifest injustice. And Cannon's like, okay, gosh. So here is what she says. Now she's about to get irritated here. Now, unlike Jack Smith's initial seal request that we talked about in the first instance, the motion for reconsideration from Jack actually proposes a legal standard this time and provides, some factual support that was missing the first time. And that filing is sealed. So Trump responded, and Trump argued that the newly raised arguments and the evidence cannot serve as the basis for reconsideration, saying, sorry, Judge, you already decided. And Trump also argued that Judge Cannon did apply the correct standard and they distinguished the cases, right? So Cannon is showing we can't see this, it's sealed, but she's telling us what happened in it. So Trump then distinguished the cases in the motion from the circumstances here. So Trump says, well, Jack Smith cited all this case law, but those were weird cases. Those were cases that mattered in, a criminal context for this person who is a foreign spy, not a president or something. So Judge Cannon gives us this, okay, so now all of these other things have been submitted. She's reviewed them. She says, okay. Now, in light of Jack Smith's motion for reconsideration, she read it. The court stayed the deadlines that came out previously, and at the court's instruction, then forthcoming motion to compel reply. And in that reply, Trump's defense was proposing that they could do this. 1, publicly file all portions of the motion to compel reply that don't reference discovery. So again, Trump's like, can we please put this on the docket publicly so we can all see it? Which we would love, because we like to read these funds. But also, 2, Trump said that they would confer with Jack Smith about the discovery that they seek to disclose. Like, what do they want to publish? And if necessary, they could then seek leave to file a redacted version of their motion to compel reply. So we'll talk to Jack. If Jack wants to white something out or redact something, we'll consider it. And the court approved this proposal. So on February 9th, Trump filed all portion of the motion to continue reply that did not reference the discovery, which Jack Smith's freaking out about. That's the actual, evidence in the case, emails, notes, and other materials. Now, on February 15th, Trump filed the instant motion for leave, right? So Trump says, okay, we're going to have this conversation about what can we publicize, what we cannot publicize. So Trump says, all right, we've conferred, we've met. Here's what we got. Your Honor, we would like permission to disclose this discovery. They identified 4 categories of material material that they want to disclose. So what are we talking about? Here is what Trump wants to disclose. These are the following materials. First, a search warrant application for defendant De Oliveira's Gmail account. And we've reviewed several search warrants here, including the search warrant that was initially launched in this case that was created by Bruce Reinhardt, I think is his name. And he submitted, we got the limited cover sheets and some basic documents about that. So what about all of the underlying, affidavits and filings that led to that? In this case, not for Trump, but for De Oliveira. So Trump wants that publicized. Jack does not. They also want grand jury testimony of an FBI special agent and a Secret Service agent concerning the thoroughness of the August 8th search of Mar-a-Lago. That was the day of the raid. They also want U.S. Secret Service an email chain shown to the Secret Service agent during the grand jury testimony described above. And they want a Mar-a-Lago floor plan and security memo that was also prepared by the U.S. Secret Service. And maybe that memo shows, this place was very secure. All of this was locked down. This was not something to be freaking out about. Trump had the documents secured because they were his documents. Now, in the alternative, Trump and the defense, they seek permission to file a redacted copy of their supplement and the exhibits on the public docket and an unredacted copy under seal. Now, Jack Smith filed a response opposing the material's public disclosure. Again, doesn't want any of this to be seen for the same reason as before. What does Jack say? Oh yeah, witness safety, infecting witness testimony or infecting the jury pool and protecting privacy interests. Now, we had a March 1st hearing. On March 1, 2024, the court heard argument on Jack Smith's motion for reconsideration. And in addition to those presentations, the court also heard argument from the press as a non-party. And here is what Judge Cannon tells us in the ruling. She says, all right, so here's the deal. So Jack Smith now seeks reconsideration of this, saying, I was wrong. Okay. Says Jack Smith says that the court was clearly wrong, clearly erred in applying the First Amendment standard to the seal requests. And these are properly governed by Rule 16. And Jack also says that this needs to be reconsidered to prevent a manifest injustice. Cannon's like, oh gosh. Namely, protecting potential witnesses and integrity of the proceedings. So upon full review, the court says we ultimately elect to consider Jack Smith's new arguments, and we do reconsider our prior rulings. And so we're going to grant Jack's ruling, in part, reasoning as follows. Now, here's where she says, before I get into this, let's have a conversation, Jack. As a preliminary point, Jack, the arguments and the evidence that actually came through in your motion, Jack, they could have and they should have been raised in prior filings. And because they were not, denial of this motion would be appropriate on that basis alone. We could be done right now. You're lucky I'm even listening to this, right? If I was Judge Cannon or I was Angeron or Judge Kaplan, that would have been the end of it. You didn't bring it up. We're done. In fact, we already have a situation like this with Judge Merchan. He's the guy in the Stormy Cohen case, the judge who is not allowing Trump to file motions because he should have filed it before. Remember that? Denied. Sorry, not timely. Should have brought it up earlier. Judge Cannon is not doing that. And the left still turns himself into a pretzels because they're so agitated that she is not doing their bidding. Now, as provided above, this is saying that motions to reconsider, like Jack, they cannot be used to relitigate old matters. You can't raise new arguments in these. You can't present new evidence that could have been raised before. I already entered judgment. Now, the special counsel had two opportunities, Jack, to raise these arguments, and you failed to do so in both instances. Now, your initial seal request failed to offer a governing standard or legal framework, and you provided no factual support for the relief that you sought. Instead, Jack, you only contain conclusory and unsubstantiated assertions about witness safety. Okay, we were saying the same thing here. We're going, what the heck is he talking about? The integrity of the proceedings, whatever that means, and the privacy interests of certain people. We're going, what? You could say that in any case, anywhere, all the time. Now, later, in response to the press coalition motion, when Jack should have corrected the record, the special counsel again failed to engage with, let alone even refute, their argument that the First Amendment attaches to these materials, that we get to see it as the public. Now, instead, the special counsel focused solely on the elements of intervention under the rules of civil procedure, and only now, Jack, after failing to meaningfully raise the arguments on present evidence, could have been raised. You could have brought it up, but you didn't. Now, after you've lost, now Jack Smith moves for reconsideration and argues in no uncertain terms that the court committed clear error. Oh, she's not happy about this. This is like, by applying an unobjected to legal standard. Judge is like, you piece of, she's very mad right now. She's like on level 9. Now, the same is true of the special counsel's manifest injustice claim. She's like, idiot. She could put idiot in here here she would, of the idiotic manifest injustice claim. She's putting it in quotes like, you're dumb. Your manifest injustice claim. Okay, let's look at that, Jack. The factual support that underlies this claim, the basis for the assertion that the disclosure of witness identities could subject them to threats or intimidation and harassment, that was meaningfully developed for the very first time in the motion to reconsider itself. Now, indeed, as the court's order already determined, the special counsel's initial seal request failed to provide the court adequate support to grant relief sought. Cannon saying, I did my job. I reviewed what you put in front of me, and you put in front of me crap. That's why I didn't rule in your favor. Now she's like being, generous. Okay, I'll look at it again. Now, although substantiated witness safety and intimidation concerns can support a valid basis for overriding the strong presumption of public access, Jack Smith's sparse and undifferentiated response fails to provide the court with a factual basis. You don't just get to dump out platitudes in your filings, Jack. This remains true even if the court had applied Rule 16 good cause, which still requires a specific showing. And this is to say nothing of Jack Smith's failure to comply with this district's local rules on sealing as well, which the court has emphasized repeatedly throughout this proceeding. Oh, she's pissed. Whoa. Look, she cited 4 different docket numbers. Electronic court filing. Oh, man. Oh, she's fuming mad. She's like level 9 out of 10. She says, hey, I've warned you about these local rules, Jack. 4 times! She had to go back, or she told her clerk or somebody, go back, find all the times I've warned him about this. It's okay. Docket 41, 48, 228, 231. She's like listing them out. You know you're in trouble when she's got a list, okay? You're in big trouble. So now this served as another independent basis for denial, right? So I could have just denied this motion, right? You are not following the rules. If she was Mershon, this would have been denied, obviously. If she was Chutkin, would have been denied. But she's an actual judge who's actually, not a partisan hack. Now, this was affirming another denial and so on. She continues. She says, all right, listen, although the record is clear that Jack Smith could have and should have raised its current arguments previously, Judge Cannon is a benevolent judge. The court elects upon a full review of the new arguments to reconsider, and having done so, here's the bottom line. The 11th Circuit has not addressed this question, which is whether in a criminal proceeding, the First Amendment qualified right of access, whether the First Amendment attaches to discovery or attached in support of a publicly filed Rule 12b motion to compel discovery under Rule 16. So can you see the discovery materials themselves, or can you see the motion that was filed referencing the discovery materials? Now, because the 11th Circuit has not addressed this, nevertheless, the most faithful application of Supreme Court precedent and available 11th Circuit authority is that the motion to compel in this case is not subject to a public right of access, whether constitutional or common law, because it is still ultimately a discovery motion as distinct from a substantive pretrial motion that requires judicial resolution. And so she says, I draw this conclusion from another case where the discovery is not subject to public review, and saying that there's a distinction here that derives from experience and logic tests from SCOTUS. So saying if we apply all this, the court agrees with Jack Smith's new position that the discovery materials that are referenced in here take on the character of a motion here, which is related to a discovery motion, which does not enable the public the right to access. Now, none of this is to say that this is clear-cut or straightforward. The special counsel's position depends on an extension of Chicago to this, but as all parties observe, there's a distinction here between civil and criminal cases, and so we can't ignore this distinction. And secondly, and more granularly, the 11th Circuit criminal cases also support, these are also distinguishable as well, saying that the public might have some, access rights in some instances. Now, as the motion to compel and the filings indicate, Trump primarily seeks a judicially enforced definition of the prosecution team, along with the ruling that Trump have produced to them some evidence tending to show the existence of the essential elements of their selective and their vindictive prosecution claims. Now, these embedded scope of prosecution team and selective and vindictive prosecution questions, says Cannon, related to broader questions of due process and bias and animus. They give the motion to compel a decidedly different flavor than a garden variety discovery standing, making the access inquiry murkier. Okay, so she's saying, look, it's a discovery battle, but it's also more than that. It's also showing that in the battle for the discovery, we are having difficulty accessing evidence, which is evidence in and of itself of a bias biased prosecution, selective, vindictive prosecution. Okay, they're not giving us access, they're hiding access, and that shows their corruption and their animus. So that makes the analysis murky. So she says, look, now notwithstanding this, these are muddled questions raised in this criminal case, but the court determines for the reasons stated that there is no right of access to the disputed discovery material referenced in the motion to compel. Now, the court therefore applies a good cause standard set forth to the categories of information below, and here's what we say. This evaluation balances relevant factors. Here's the judge. Now, we're going to balance the safety of witnesses and third parties, danger of perjury or witness intimidation, protection of information vital to national security, and the protection of business enterprise from economic reprisals, adverse actions. So the special counsel says the good cause burden rests with the defense. The court disagrees and saying if we apply this here, this is what the court is going to do. So Jack Smith, when it comes to witness identities, Jack Smith seeks to redact from Trump's motion to compel and exhibits information that reveals the identity, right? No identities of any government witnesses. Jack says no. If we publicize their identities, then they could be subject to threats, to intimidation, and to harassment. Also to scrutiny, to oversight, to research, to investigation, but they don't want that. So Jack Smith offers examples of threats and concerning communications that judicial officers got, like, Engeron or Chutkin or Cannon. Cannon had somebody who was even arrested for this. And law enforcement agents connected with proceedings, like the search of Trump's home and other things. So Jack also filed under seal evidence related to a government witness by a non-party referenced cited in the motion. Now, Jack Smith acknowledges that no defendant in this case has done witness intimidation and that all defendants are subject to a no contact order that has generated no activity in this case, right? So the defendants are following the rules. No one's breaking the law. No one's doing anything bad there, obviously. So Cannon says, now, although Jack Smith's request remains sweeping in nature as applied to all government witnesses without differentiation, and although the court was unable to locate another high-profile case in public records where the court granted a broad pretrial request to seal all the identities as sought here, the court's satisfied that Jack Smith has made an adequate showing, at least at this juncture, pending final trial preparations. Now, the court directs Jack Smith to file under seal an index containing the name of each potential witness and a corresponding pseudonym or anonymization for use in the motion, right? So the names will be gone out of there. So personal identifying information, this one I had less of a problem with. Now, Jack Smith and Trump, right? Even Trump is requesting redactions. Okay. The court previously granted this request. No party challenges it now. So therefore, consistent with this, we'll do that. Redaction of personally identifying information is okay. Now, how about witness statements? Now, as for the third category, Jack Smith argues, he says, in what is characterized as a part of a narrow set of seal requests. He says it's narrow. No. The wholesale and the undifferentiated pretrial sealing of all information that he says is Jenks Act material for government witnesses. And Jenks Act material is material that the witness will rely on or testify to or use in their testimony. So the special counsel contends that this information should remain sealed because of witness safety, not to influence witness testimony. And in response, Trump says there's no case supporting this position. Upon review, the court grants that in limited part. They say the court finds good cause to redact limited portions of the material that could identify them, right? In sync with the prior order. Limited redactions, like professional titles, detailed biographical background information that could identify them, personal identifying information, other specific stuff. Sealing this is supported by the same witness safety rationale, and it supports the idea if we're going to redact their names, we should redact their resume. The parties are directed to meaningfully confer and redact all of this. And then lastly, or remaining, the court reaches a different conclusion about the request to seal the substance of all the statements. So Jack wanted everything limited, but they say no, that's too broad. The court does not find that Jack Smith's generalized witness and jury pool influence concerns are enough to establish good cause to categorically seal all of this. So in light of the strong presumption of public access, the court declines to seal everything. Now, to date, Jack Smith has had multiple opportunities to provide factual and legal support for the contention that generalized witness and jury pool influence concerns justify a blanket sealing of all witness statements. None has been provided yet. All Jenks request support included in the motion is offered as justification to witness safety. And so the good cause showing is inadequate, and the request is generalized. It's undifferentiated. And so we're not going to apply it to all witnesses regardless of substance, context, or role. The court has found no analog for this type of request, which arises in a case involving a lengthy speaking indictment that generously references and quotes from a variety of non-defendant statements. So as for legal authority, Jack Smith's cases do not lend support for this request, and the court's independent research does not support this request. And so we're not going to be having a categorical sealing of all the substance. So in sum, Cannon says the court finds that Jack Smith has made sufficient good cause to show that there are some redactions justified for information in substantive statements that could be used to identify the people. If you're confident it's going to not identify them, that's fine, but we're not doing a wholesale limitation and redaction of everything. Now, Jack also identifies documents that contain additional discrete sensitive information in other categories. And as in the court's initial order, the court finds that national security concerns are sufficient to warrant the sealing of the signal intelligence subcompartments that are redacted in the indictment. Additionally, Jack requests that the FBI code name of a separate investigation and other uncharged conduct not be mentioned. What could that be? A separate investigation. I wonder what that one is. Like Crossfire Hurricane or something? I don't know. The court determines that law enforcement and third-party privacy interests are sufficient to justify these redactions. And finally, unlike Jack's requests, vis-a-vis Trump's substantive motions, the seal request does not seek the redaction of the ancillary names. But nonetheless, for consistency, we're not going to be identifying people, and we authorize the sealing of this. Now, in their leave for motion to disclose the discovery, Trump wants to disclose other materials. Jack Smith opposes those materials, the ones that we reviewed previously. Each is discussed below. Trump wanted to release the search warrant. Jack Smith opposes that. Now, consistent with the holdings, the court directs Trump to redact from these materials what we talked about: the PII, the Jenks material, and anything that might identify, but it sounds like otherwise we're going to see some of that. Grand jury testimony. Second, Jack Smith opposes the disclosure of grand jury testimony about an FBI agent and a Secret Service agent. He says those should be sealed. They're protected. Now, consistent with this, the court does find good cause to seal this material, so we're not going to see it. Trump should redact grand jury testimony, so that exchange, from their supplement and do not put them in the public filing. Secret Service email chain. Are we getting this one? Third, the special counsel opposes disclosure of a Secret Service email chain. They call it paradigmatic Jenks Act material. Says it has to be sealed. Trump intends to reference and quote these emails insofar as they relate to the thoroughness of the search. Now, Trump is directed to redact any identifying information. And lastly, the floor plan. They say Jack Smith opposes a memo that was prepared by the Secret Service that was a floor plan of Mar-a-Lago. The court finds good cause for sealing this. Why? National security, law enforcement justifications. Don't want anyone to know what it looks like. And so Trump is directed to redact all of that. And so it is hereby ordered and adjudged, granted in part, denied in part, and the judge is setting some deadlines here. Okay, by April 15th, we have Jack Smith, who's been ordered to create an index of the witnesses, meaningfully confer about redactions of Jenks Act material, meaningfully confer about, what's going on, the public docket, and signed by the judge in Florida. So a little bit of a bummer. This is stuff that we all like to see. We'd like to see basically everything if we could get our hands on it, and we'd read it if we could. But she's trying to balance this thing out, and, we have no idea what they're talking about or what the documents look like. So it is a bummer, but you can see Jack Smith got a very serious dressing down there, and his hysterics are not tolerated in Judge Cannon's courtroom. And quite frankly, right, she is more of a middle of the judge road. But if she wanted to be a, ultra Trumper, like somebody like the opposite of Judge Chutkan or Judge Engoron or Judge Kaplan or Judge Merchan or any of these other judges, she could have just disposed of this immediately, right, and shown us what we wanted to see, but she's not doing that. So we're going to see what continues to happen on this. Of course, we'll see what some of those documents look like. I can't wait to see some of those chains if we can get our hands on some of the Secret Service stuff or whatever we're going to get our hands on. We'll be here covering it. And so thank you for subscribing, my friends. Wherever it is you're watching this, we're covering all of the Trump litigation, all of the 2024 litigation. We got a great members-only community, watchingthewatchers.locals.com. We do streams in the morning, Saturday streams, and we have a great group of people. Links all down in the description below. We'll see you over there and back here on the next one.